By implementing these parental exclusion policies, they are presuming that the parents are unfit, and they're substituting the state's judgment for the parents' judgment. And the parents are responsible for bringing up their kids, instilling their values and morals in their children. And it's not the state's role to circumvent that and not even tell them about it. And that's one of the things in so many cases is not only are they doing this, but they're purposefully keeping the parents completely out of it.
Welcome to the Napa Legal Podcast. I'm Joseph Clement, the Content and Program Manager at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we'll be covering a new cert petition to the Supreme Court to protect parental rights, donor privacy at the Arizona Supreme Court, and a potential ban on public prayer in Quebec. Before moving into our updates, I'd like to introduce today's guest host, David Kolenda, who's filling in for Frank DeVito. David is a corporate and transactional attorney with the Burke Law Group. He is a graduate of the University of Texas School of Law and previously worked at a large law firm in the Dallas area. And David was a 2024 fellow in the Good Counselor Project. So thank you so much for joining us, David. We're really grateful to have you here.
Joseph, thanks so much for having me on. I'm really happy to be here. I was a Good Counselor fellow in 2024 and had such a wonderful experience doing that and learning about all the great work that Napa Legal does.
Great. Yeah, well, we're more than happy to have you today. So with that, since we have a few big things to talk about this week, we're just going to go ahead and dive right in. So we'll start off with a current cert petition from some parents in Florida asking to defend their parental rights in what could be a very consequential case. So the fact pattern itself is kind of unfortunately familiar. Basically, the school board in Florida ratified a parental exclusion policy, basically saying that if a student says to the school board, hey, I'm going to start going by pronouns other than my biological sex and identifying by a different gender. If the student doesn't want the parents to know, the school will say, we're not going to tell the parents, and we're going to keep all of this between the student and the school administrators. And this one particular student, she's referred to as AG for privacy reasons, had some serious mental health issues starting around the COVID era. Her parents were aware and they hired a private therapist and were trying to handle things at home. And the parents reached out to the school and said, hey, our students, we hired a private therapist, we're trying to handle things. And our student wants to go by they, them pronouns. We're not going to be doing that. And told the school, don't do this, just kind of respect our wishes and just don't do the exact opposite of what we want you to do. Shortly after this, the student reached out to school staff and asked them to start calling her by different pronouns. And the school immediately said, yes, we will. And since the parents were, quote, supportive, they had to maintain privacy. So they never notified the parents and were going to keep everything kind of between the student and the school administrators. Fortunately, pretty quickly, the parents found out and reached out to the school telling them to stop doing this, right? They had this conversation earlier and said, this is directly against what we want. You have to stop. And the school, according to their policy, refused. And they also refused to disclose any information that AG and the school counselor and principal had already discussed because of privacy. And actually quoting the school principal, they said that the parents, the Little Johns is their name, could become more involved in the student support system if they affirmed the student's orientation of non-binary. So we've talked about these sorts of parental rights cases before on the podcast. There was one in June or July over a New York school's pretty similar actions. But the legal questioning going on here is a bit different from other ones. And I think this is the first time we're actually having this claim petitioned to the Supreme Court. So the district court dismissed the Little Johns' claims on the due process clause, and the circuit court affirmed this dismissal. So as of right now, the Little Johns lost their case, and they're asking the Supreme Court to take it up. And the legal dispute centers around the application of the shock the conscience test, particularly when non-enumerated fundamental rights are violated by executive action. So there's the mouthful. We try sometimes to avoid getting too into the weeds, but this is kind of a weedy and important question, so we'll dive in a little bit here. The Due Process Clause protects two different types of rights, those that are enumerated and those that are unenumerated but fundamental according to the history and tradition of America. So in this case, we're dealing with an unenumerated fundamental right. Right, the parents are saying we have the right to direct the upbringing of our children. Throughout the history and tradition of the United States, that's been respected, but it's nowhere in the Bill of Rights. Likely because at the time of the Bill of Rights ratification, nobody thought such a thing would be necessary. But in this case, we see it is. So we're dealing with an unenumerated fundamental right to direct the upbringing of your children. And that actual point isn't disputed. There are a few different tests to determine what level of judicial scrutiny is required in a case like this. So on the one hand, when there is a fundamental right that's implicated, strict scrutiny typically applies. When there's a non-fundamental right that's implicated, it depends on who's acting. If it's a legislative body, rational review is applied, which is a pretty low standard, as our listeners probably know. If executive action, as in this case, since it's the school board, then the test that gets applied is the shocks the conscience test, which is a very stringent, for something to legally shock the conscience, it has to do a lot of pretty wild things, which we'll dive into shortly. So the key point in this case is that in general, for a court to rule in favor of a plaintiff in a due process claim like this, the challenged activity, when performed by an executive actor, must either A, implicate fundamental rights, or B, shock the conscience. And in this case, the court basically decided that both have to happen. So the shock the conscience tests, the circuit court held that since the school was trying to help the student, per their words, it doesn't fail this test. It's a very high bar, even when school officials in the past, out of negligent activity, has caused deaths of students. Courts have ruled that their actions didn't shock the conscience, right? It says that the most egregious conduct meets the standard, and only the most egregious conduct. And it basically has to be an intentional injury that isn't supported by any government interest. So before handing it off to David, just a few notes on the implications of this case, which are probably already kind of apparent. We've mentioned before how our legal system tends to protect religious liberty at large. Like we've talked about this with Section 1983 claims and just like last week with some employment law. But when properly applied, our legal system often protects religious liberty. Now, in this case, if this ruling is upheld, schools will basically be free to do what they want and to violate parental rights under the guise of helping students. So if conduct has to, quote, shock the conscience for it to violate the due process clause, like the circuit court ruled here, it makes it nearly impossible for parents to vindicate their rights in court. So David, I'll hand it off to you to continue on this one.
Thanks, Joseph. That was a great recap of what's going on. One thing I wanted to highlight is that the appellate courts, as they are in many cert positions, are split on these issues, and the courts have actually said that they are confused as to when to apply the shocks the conscience test. So beyond just there being a circuit split, one circuit says one thing, another circuit says the opposite, the courts that are interpreting it are saying that they're confused. They don't know when they should apply it. And then to move on to some of the more of the implications of this. This is at a time where, if you have kids in school, you know that you need permission for absolutely everything. You need permission for, teachers to give your child an aspirin for a headache. And yet over 1,000 school districts have adopted these parental exclusion policies throughout the country where they can take much more serious action than, giving a standard over-the-counter medicine to your child. They can have much more serious and long-lasting effects. And then in terms of on the parental rights side, by implementing these parental exclusion policies, they are presuming that the parents are unfit and they're substituting the state's judgment for the parent's judgment. And the parents are responsible for bringing up their kids, instilling their values and morals in their children. And it's not the state's role to circumvent that and not even tell them about it. And that's one of the things in so many cases is not only are they doing this, but they're purposefully keeping the parents completely out of it. And as Joseph mentioned, the parent-child relationship, is time-tested in American tradition and also in the British and Anglo-American legal history. And it's the most universal relationship in nature. You know, everybody has a parent. Um, and it really pushes back against the role of what that parent-child relationship to be and should be if you're excluding parents from these fundamental decisions that they should be making.
Yeah, no, absolutely. Like you said, there's a lot of, the legal issues, but legal issue aside, it's so clearly contrary to, the basics of human rights and of human dignity that's been recognized not only in the US, but really throughout a lot of human history.
Yeah, absolutely. And then moving on to the next topic we have is the donor privacy laws in Arizona. And actually, this was just argued yesterday, September 11th. We're recording this on Friday, September 12th. So on September 11th, it was argued at the Arizona Supreme Court. So it'll be really interesting to see how that court rules and how that kind of plays. But to give a little background on the act, in 2022, Arizona passed the Voters' Right to Know Act, and it's a proposition that requires nonprofit organizations to disclose the names, addresses, and occupations of certain donors who give in conjunction with campaign media spending. And we'll get back to what that means going forward because that's part of the issue at the court. And while tax-exempt organizations like 501c3s are generally prohibited from campaign activity, the way this law is written leads many non-political organizations to be forced to disclose identifying information about their donors. And several Arizona nonprofits have filed a lawsuit to prevent the enforcement of this law, and they argued it yesterday. And their claim is that the law is unconstitutionally overbroad and not narrowly tailored to the goals that the state is claiming they're trying to do. In the cert petition that was filed, they say that an individual who donates to his church may have his or her name and address given to the public under the act. And this case really provides a good roadmap for mounting state constitutional challenges to donor disclosure laws across the country. So to get into a few more of the specifics of the law, it says that any donor who gives more than $5,000 to an organization that performs any action in conjunction with actions comprising campaign media spending will have their name and information disclosed. And the state has claimed that they have an interest in anti-corruption and in informing the public about who is supporting different political candidates. But the way the law is written goes well beyond that. And so the way that this court comes out could be really interesting in terms of how it informs how other states are going to go about this. In terms of disclosure requirements, broadening them, restricting them. There was a report at the beginning of the year from People United for Privacy that 34 states have implemented or are considering implementing donor disclosure requirements. So this is not a one-off, this is not just about the state of Arizona. This is about, 2/3 of the states in the US. And interestingly, it's not a partisan issue. There were 34 states that were identified as either have implemented or considering implementing, and half of them are Republican controlled, half of them are Democratic controlled, and then a few of them are split. So it's not a left-right issue. It's really it's a donor privacy issue that really could create a chilling effect on speech if people know that if they donate a certain amount, that their name and address and business is going to be disclosed to the public. That could really prevent people from donating and exercising their free speech rights to donate. It makes me think of Brendan Eich, the founder of Mozilla, who back in the early 2000s, it was leaked that he had donated to Prop 8, and he was kicked out of his leadership role at the company that he founded. So it really has the possibility to create a chilling effect on speech if people know that they're going to be, they're going to be outed as supporting these different nonprofits. The Arizona Attorney General argues that this only applies to large money donors. But the way it's written is so broad that, well, one, it's for $5,000 donations. So it's not small donations, but it's not, we're not talking about millionaires and billionaires. These are people that are donating to causes that they truly support. And then in terms to back up and go into a little bit of the history of donor privacy, the first big seminal case in donor privacy was NAACP versus Alabama, where the U.S. Supreme Court held that the state of Alabama could not force the NAACP to disclose their donor list. The state of Alabama in that case spent about 8 years trying to force the NAACP to disclose their donor list because they wanted to be able to, you know, drive them underground and drive them out of the state um, and keep the NAACP from existing and fighting for the rights of African American citizens. And so that was a seminal case in the 60s that really highlighted the importance of donor privacy laws. And then Buckley v. Valero and Citizens United were some additional cases that held that disclosure requirements are unconstitutional if a plaintiff can show only a reasonable probability of threats, harassment, or reprisals. And the plaintiffs in this case have shown that they have gotten threats and harassment based on their donors being disclosed and based on their involvement in this case. So the Voters' Right to Know Act removes these essential privacy protections and requires the Secretary of State to publish the names, addresses, and occupation of every donor who reaches that certain threshold, even if the donor did not donate with the intent to support the political message. That is the way it's worded. It's very vague and overbroad. They define it as every action performed in conjunction with actions comprising campaign media spending, which, if you think about that for a couple of seconds, you go, well, that could be really just about anything. So there could be people that are donating to a nonprofit that they support the mission of, and they don't even think they're going to be on this donor list because they're like, this nonprofit does not, they don't do campaign media spending. But because of the way the law is written, it could absolutely affect them. So this could affect even people that don't think that they would be subject to it. And this really just cuts at the heart of freedom of speech and freedom of association that are so enshrined in our political tradition, in our legal tradition, that, you know, you should be able to say what you want, and you should be able to associate with groups that that you want without fear of reprisal and harassment and threats. And Joseph, I would love to get your thoughts on this case.
Yeah, thanks that was a great explanation of what's going on here. And like you mentioned, a lot of states have laws like this, and they cause real harm to a lot of people. And at first glance, it seems like it's oriented towards revealing, basically, like you said, corruption and who's backing certain political candidates. Um, it seems to target mostly 501c4 organizations, which tend to be more political. They're not charitable and religious. They're defined pretty broadly for promotion of social welfare, but in effect, a lot of them turn into political organizations. And by itself, that has some constitutional implications when they're doxing these things. But the actual effect of the law is way beyond that because of how overbroad and vague it's written, like you mentioned. One of the plaintiffs in the suit against this Arizona law is a 501c3. And those are organizations that are operated primarily for religious, charitable, and a couple other purposes. But this isn't only impacting political organizations. This could is impacting religious and charitable organizations that don't engage in campaign activity. That's actually grounds for losing the tax exemption as a C3 is if you engage in particular types of activity and back particular candidates, you lose that designation as a C3. But some of donors of these religious and charitable organizations could have their information leaked and actually probably are having it leaked because of this law. So not to give anybody ideas, but if the law is actually designed to target only political donors, it would be written very differently. And it's just so broad that it clearly is going to capture so many people that have nothing to do with politics. And like David mentioned, this has a huge chilling effect, and this chilling effect was actually acknowledged at the trial court level. Part of the Arizona lower court's decision was that people who don't want their information leaked can, quote, opt out of contributing to campaign media spending. So the court said, oh, if you don't want to have your information doxed, then you can't engage in this particular type of protected speech. So it's not just kind of a legal theory. This is actually what the court is saying is going to happen. And we're very, very glad to see this reaching kind of a higher state at the Arizona Supreme Court. With that, we'll go into our last update, which will be a little shorter because it's a bit more straightforward and it's still pending some more updates. But basically, some legislators in Quebec have indicated that they're going to introduce a ban on public prayer. So we don't often on this podcast talk about international law and policy, right? It's just kind of out of our sphere of expertise, and it's a little bit unrelated sometimes to faith-based nonprofits in the U.S. But some things like this one we're talking about are so blatantly contrary to natural human rights that we feel the need to bring them up. So there's no actual pending bill yet, but several Quebec officials have announced a plan to ban all forms of prayer in public. The province's secularism minister, I didn't know that was a position until reading more about this, but he stated that, quote, the proliferation of street prayer, so just prayer in public, is a serious and sensitive issue. And in order to combat this serious and sensitive issue of people praying in public, the administration plans to entirely ban this street prayer. So David, I'll hand it to you to get into some more particulars about what some leaders have said in response to this.
Yeah, thank you. I mean, this is one that kind of just beggars belief that they would try to ban prayer, which it reminds me of the woman in England who was arrested for praying silently in her head, where you start getting into this is not just, it almost goes beyond freedom of speech to freedom of thought at a certain point. So like you were saying, Joseph, just want to highlight a couple of things. One, that the premier of Quebec said about why he wants to implement the law, and then a couple of the responses by the Archbishop of Montreal. So the premier, Francois Legault, said that seeing people praying in the streets in public parks is not something we want in Quebec. Which to the American ear, that sounds like, well, that's completely unconstitutional. And I'm, no expert in French or in Canadian law. But it's the kind of thing, if the leaders are saying that, if that's the way, it almost doesn't matter what the law as written is, if the populace is, expressing these sentiments and is so hostile to religion and to prayer. Another thing he said was, when we pray, we go to a church, we go to a mosque, but not in public places, which is, that's confining your religious practice to just in the church, which is completely antithetical to what freedom of religion actually means and what the practice of religion actually means. We're called to bring our faith into every aspect of our life, and not just, sequester it into whenever we go to church. But the Archbishop of Montreal, and I'm not going to attempt to pronounce his name because I probably already made that mistake with the Premier of Quebec with the French names. But he wrote a letter denouncing this proposed bill, saying that at its core, to forbid for public prayer would be somewhat like forbidding thought itself, which just rings so true in terms of forbidding public prayer is that's almost like a hallmark of a totalitarian regime. That's something you would see in some sort of dystopian novel or dystopian movie. And then he also highlighted that it would jeopardize traditions deeply rooted in Quebec, such as the Way of the Cross, the Palm Sunday procession, Feast of Corpus Christi, and really any other, religious event that doesn't take place simply in the church. Pope Francis visited Montreal in 2022, and we don't have an actual statute to go on, but if public prayer is banned, the Pope can't come and speak in a public place without presumably, getting some sort of prior approval to be able to say what he wants and pray. And that just seems wild that those kinds of things are being, even if it doesn't get adopted, that these things are being given serious consideration, is a really, really negative sign. Joseph, I don't know if you had any other further thoughts on this.
Yeah, I loved one of the Archbishop's notes in the letter he wrote explaining the problems with this potential bill, is that it doesn't seek to secularize the government, but it's trying to secularize society. In and of itself, the government doesn't have the authority at all to say you can't be religious, right? And it's not actually a bill here that's trying to remove faith from administrators and from like a separation of church and state kind of thing, whole nother can of worms there. But what it's trying to do here is saying people themselves don't have the right to be religious and to express that. And something like this would impact every group, faith-based or not. In Canada, Catholic, like the Archbishop leaders have spoken out, Muslim leaders have spoken out, as have secular. The Canadian Civil Liberties Association has no particular religious affiliation, and they've explained how this is seriously problematic. And that's because the freedom to worship is so fundamental. In the United States, at least, the Bill of Rights starts with the freedom of religion. In Canada, the Canadian Charter of Rights and Freedoms, the very first freedom mentioned is that of religion. In the UN's Declaration of Rights, it's not till like number 16, I think, but it's still in there. So the freedom to worship is such an essential, fundamental part of any society. And worship doesn't only occur in the home, in the church, in the mosque. It's something that if you actually believe in, and you're actually kind of compelled, depending on your faith, it's going to usually bleed into the public, at least a little bit. So we're very hopeful that this bill stops just at the speculative stage and doesn't actually reach any sort of legislation. So David, thank you so much for joining us today. It was such a pleasure to get to talk and hear your thoughts, and you've contributed so many wonderful things. We'd love to have you back sometime.
I had a lot of fun, and I think that's a great way to end it, is talking about the importance of prayer in our personal lives and in our public lives, and how important that is.
Yeah, no, absolutely. And for our listeners, thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we'd appreciate it if you like this podcast and subscribe on YouTube, Spotify, or whatever platform you're listening on. We hope you'll join us next week as we continue to discuss and highlight some of the most important ongoing legal and policy issues that affect religious liberty and the work of faith-based nonprofits. We'll talk to you next week. Thank you for joining us, and God bless you.